Hi, good afternoon, and welcome to our webinar of today on the topic of debt collection in Central, Eastern, and Southern Europe. Together with my colleague Enrica, we will be giving you today a short presentation on this topic, and we'll as well give you 5 tips on how to handle debt recovery matter. So, moving onwards, we're gonna switch to the next slide. My name is Alex. I'm a senior attorney and quality manager within Bigazzi. I've been with the firm for 11 years since September. And I'm mostly active in Eastern Europe, and I handle international private law matters. And my colleague?
Yeah. Good afternoon. I'm Enrica Bigazzi. I'm an attorney at law under Italian law, and I'm responsible for the Italian desk and the South European desk. And I have been working for Biren since 2016. Long time as well.
Long time. But a nice time. We are a law firm established since 1950s. We have our headquarters in the Netherlands, with an international office present in Amsterdam. As well, we have offices which are present in the most active European countries with which the Netherlands does as well business. We have a sales office in New York in the United States. And our coverage is global due to the network of lawyers that we make use of. We assist clients of all kinds, from sole traders to SMEs or large companies. And we have experience in several fields of law, but with a focus obviously on debt collection. Here you have the map of coverage, where you can see that only the light gray parts are covered with parties that we work with. The rest is covered by us in-house. Moving onwards with the contents of the presentation, we start with the cultural differences, which impact quite a lot our line of business as well. You need to be prepared. You need to switch from a national mindset to an international one, obviously. And we start with the difference in the sense of time.
Yes. I would say that in Southern Europe, there's more tolerance in sense of time. For example, on the other day, I had a debtor on the phone who said, yeah, but our invoices are expired only last year, or said, okay, it's
only 1 year.
Only 1 year, but it's a long time. But also we see in the general attitude with debtors, and also according to the law in Italy, for example, when you ask for a payment, you cannot expect a payment within 3 days, but we always give 15 days. And it is reflected also in court procedures, where there is more, I would say, time for debtors to comply, and they are given multiple occasions to do that. And it's totally different from the rest of
Central Europe, let's say. Yeah, in that sense, that's already a good tip. You'll see it at the end. You need to adapt also your notices as a credit manager within a company, because otherwise you risk of looking a bit like an alien to, let's say, an Italian debtor. The same goes for formalism. That's also something you need to take into account. There are countries like Germany or Austria, where addressing somebody with the right title can go a long way, compared to other countries which are, let's say, a bit more flexible on that, calling, say, like the Netherlands, where you call people on their first name. That is actually preferred than calling somebody doctor Italy has the same, I guess. I
Yes.
heard always dottoressa,
Yes.
dottore.
Yes.
Yeah, yeah.
Or
You can see the
avocado.
differences.
Yes.
Avocado.
Yes.
Same goes for hierarchy. There are certain countries where hierarchy plays a big role, others where not. We're discussing earlier about receiving the email from the right person within a company, if that matters or not. There are countries where that actually matters legally, and countries where that doesn't make any difference whatsoever. On the topic of limitation periods, we have a separate slide. We will show you there, also linked to the idea of time, what differences exist between Central, Southern, and Eastern Europe.
And now we are going to talk about the possibilities to investigate your debtor, or at least to have an idea of the company you are dealing with. For example, if you run a credit check on a company, you can have access to the national database, for example, in Italy, la Camera di Commercio, where you can retrieve also balance sheet and important information, as well as the European e-justice portal, where you can see also payment behavior, reliability, creditworthiness, which is really, really important when you start doing business with a company, an international company, a foreign company. And another important aspect, especially for, I would say, Italy, is to understand the assets of a debtor, because it's also important in case of enforcement. You need to know already the goods that belongs to the debtors. We will talk about this later in specific slides. But it's really important to understand which kind of assets the debtor have. And for example, we as Birens, we can provide investigation report. We work with certified providers, and that can make a check on the debtor's assets. And of course, we can also ask the bailiff to do so, but only while a trial is already pending. And as we will mention later, it's really essential to make an investigation on the debtors.
Yeah, I remember now a funny story that we use also for Spain investigators to go and purchase from stores that do very often sell, let's say, sports clothing. That we send them to just buy a small item, so they get a receipt to see which VAT number appears on the invoice, to know if a certain still the same legal entity runs the shop, because very often they change legal entities. They still keep the same name, same shop, maybe same employees, but then a different legal entity ends up running it.
Exactly. It happened the same in Italy.
Yeah.
We wanted to check. We were supposed to get certain items again for maybe sport, and then we got an ice cream.
We had an ice cream.
Yes.
Big surprise.
Yes. Yeah, in this slide, you can see the European Justice web portal, where you can see checked insolvency, land and business register is very useful.
Yeah, and also good to mention that exactly what you gave here as a link. There's the national registers and the European Union register, which is a project to unify all registers into one. Bankruptcy as well, company information in another topic. You have European procedures like the European Order for Payment or the Small Claims Procedure. Those are obviously unified within all EU member states. But on the other hand, you have national legal proceedings, and we as lawyers with experience in international private law assist our clients by choosing where to proceed based on the possibilities of the file. But if we have the possibility to choose, because that sometimes exists, we know to compare between procedures that can take place in Central, Southern, and Eastern Europe. I will let you read what's on the screen. I'll just tell you in one sentence to highlight. Central and Eastern Europe, they run the same timelines, with Central Europe having more predictability on enforcement. Southern Europe takes a bit more time for reasons which we will show a bit later as well. but still enforceability remains reliable. While for Eastern European countries, you see more often that companies tend to file strategically for bankruptcy, or people just alienate assets from the company.
And yeah, with this respect about enforcement of judgments, there's a big difference, for example, for Italy in comparison with other countries.
Let's compare with Romania.
Yeah, okay, let's do that. Because, for example, in Italy, there's a lot of burden on the lawyers and not on the bailiff, because we need to already address the bailiff to which goods and real estate or property you want to seize.
Yeah.
Because you need to know exactly what are the banks and
the bank accounts.
The bank account, in which banks, and also the real estate. You need to be very specific on the land and register, cadastre, and there is a lot of formalism also in this.
Doing to file different requests.
Exactly, different requests for each specific enforcement.
It's completely different than with us. We give basically instructions to a bailiff, and the bailiff just does everything in one go. Keeps a bit the enforcement on real estate behind, but checks on all banks. Checks immediately if there's property. So there's a bit less burden on us lawyers, and maybe you need just to follow up now and then to see what was done in the meantime. Yeah. It differs.
Yeah, but also, for example, you can be in the middle of a trial and then you don't know what to seize. Then you can ask the bailiff, so he will show you exactly the bank and real estate. But then again, you need to choose what to do and be specific and address the right bailiff, the right question.
Yeah, very interesting to see all the differences. Yeah. Moving forward. The limitation periods are listed that you can consult yourself. To highlight a bit the differences, you will observe that Southern Europe has a significant higher number of years for limitation periods. Spain is noticeable. It reduced from 15 years to 5 years in 2015. It's a reform they've done to change a bit the trend. But Portugal stands out with 20 years. This shows you the perception on how time is being considered. Everything for everything there's more time being granted. Be mindful that in a dispute, the limitation period that applies is definitely determined by the law of the seller or the service provider. So don't think which country my debtor is and then check the list. But on the other hand, on the contrary, you need to check based on your own country of origin. And with this, we come to the essential debt collection tips.
Yeah, of course, we would advise you to ensure written confirmation of your claim. Of course, in this way, you have an acknowledgement of debt, and this will, I would say, make it easier to court, for example, in case the debtor doesn't comply anymore. You can obtain an enforceable title with immediate enforceability. So it speeds up the procedure once you are in a trial. And it's also important that the payment plan, for example, covers the entire claim, so also interest and costs. So try to be not to skip the interest for any reason at all, and also, of course, compensation for the legal costs that your company had to incur with. As said, try to get written confirmation. And as Alex said before, in Italy would be great if the written confirmation is given by the person that has the authority to do that. Because then it has more power in court
Yeah,
in the future steps.
it will stand. Yeah.
Yeah.
Yeah. There is mentioned small amounts are also sufficient. It's also
Yeah,
linked to the limitation period, I think.
exactly, because it
Yeah.
interrupts the limitation period and it gives you also again a proof and acknowledgement of debt. So it's
Yeah.
already a statement
Yeah.
also.
Yeah. Definitely puts you in a better position. Yeah. Investigate the reasons that your debtor is not making payment on time. Yeah, I think our viewers are quite experienced as well in hearing debtors all sorts of excuses. Um, you will hear very often excuses linked to the market, and that you hear these days more often, I believe, right?
Yeah, in Italy, yes,
Yeah.
absolutely.
It's good not to remain passive when such a claim is made. It's a good practice to challenge a bit your debtor, request financial documents like recent statements, which maybe have not been made public. You can ask your debtor maybe to give a statement where he says what assets he have, or he can give you a list of his receivables to understand what is his future. Also, do not fear to place that question and ask him, are you considering to file bankruptcy, or are there any other parties which have significant claims against you? These are all questions which I believe help to get a debtor realize that you're serious, because then you're checking more on what possibilities you actually have to
Exactly.
legally collect the claim.
Absolutely. Yes. And yeah, of course, it's better, I think, to solve issues as soon as possible. And maybe concessions made before going to court can avoid long trial procedures. So be aware that, as we mentioned before, in Italy it takes a long time in sense of procedures and trials. So I think it would be advisable to make payment plans within 6 months to be paid,
Yeah.
no more, because then, of course, if they dispute the claim, they start delaying, it will be more difficult to get your money back. And for sure, I believe that debtors decide which creditors to pay first. So if you make a lot of pressure on them, they will start paying you maybe instead of others, because they know, okay, this I can wait a little bit more. They are
The
very
more
patient.
understanding.
Yes, they are
Yeah.
more
Yeah.
understanding. They are patient. But so you need to push in that sense a
Yeah.
lot.
Yeah.
Yeah.
Maybe it's worth mentioning here. I have a lot of clients that are surprised the moment a case is given to us and it's undisputed. Even though the receivable, the debt is maybe 1 or 2 years old, at that moment comes a complaint in, and I
Yeah.
think everybody sees that.
Yeah.
And then you ask yourself, why did this person do so long?
Mm.
And very often our clients have this logic where they say, well, they haven't disputed so long, they cannot dispute anymore. Or even more so, you can end up in court and there you hear the first dispute, and our clients believe that that's not possible anymore. It's possible till the very end. So that suggestion that we make to make agreements in written, to get admissions, to get small payments, it actually creates a more secure position, and it gives you more chances to succeed than if you just have maybe a conversation on the phone or a WhatsApp exchange, something that's less official.
Absolutely. Of course, there are strict deadlines, for example, for defects. Our clients sometimes says, no, but they didn't raise any claim within the 8 days, for example, or when the defects were discovered. But still, as you said, they can do this till the very end.
Yeah.
And that's also why it's important to make sure that you have all in written, and because we also have communication, WhatsApp and audio messages that a recent court sentence approved and stated that.
Yeah.
On the other hand, it's very difficult because then you need also to check exactly when it was recorded, what was the issue, do you have pictures attached that can prove exactly the same thing, so all things come to the same line. And sometimes it's much better to have a conversation over the phone, but then confirm in writing what was said.
That's one of the best things you can do in debt collection. Counts for us as well.
Yeah, true.
We always follow up with an email. That's the basic. Well, ideal world, you would ask for payment in advance. Well, if that would happen 100%, then I think we wouldn't have a job anymore.
Yeah, exactly.
But unfortunately, that doesn't work all the time. So do your best to ask the payment in advance. If not, especially with those parties that default, that have difficulties paying you, just know and remember that you are allowed to ask for potential securities even after the fact. That's absolutely okay. There are a couple of securities mentioned on the screen there. The Netherlands, for example, has a thing called the recht van reclame. So it's also a form of retention of title, or the right to cancel the sale and request directly the property back. For our Dutch listeners, that's always good to remember that exists. And otherwise, maybe also good to mention that France, but also Romania, also Bulgaria, Hungary, these regions still use promissory notes as a security. They're given blank with instructions to fill in. And the most interesting thing is that those promissory notes are enforceable titles. So once you need to put them in practice, you fill them in and you hand them over to the bank. If they're refused, you get them automatically enforced based on the refusal of the bank to give the money for example, lack of finances. A very powerful tool, and you need to again check with a lawyer from that specific country who has specific knowledge to tell you if that's something that's often done in that country. I mean, if you ask in the Netherlands, you will be seen as strange, but if you ask in Romania, it will be seen as absolutely normal.
Yeah. And with this respect, for example, the same happens with checks in Italy.
Checks as well. Yeah, same thing.
So bounced checks can be used as a title, enforceable, but only within 6 months.
6 months,
you
indeed.
and in Spain is 1 year.
Yeah.
So you need to be very act really quickly.
Definitely.
Yeah.
Definitely.
Because, and of course, if you see that there's a bounced checks, of course. You can think that that bank is empty. So that's also, again, it's important to make an investigation on other
maybe there's another bank account.
Exactly.
Yeah.
But it's really useful tool.
Yeah, the check will not work against that account, but if you get it enforceable, it will work against another account.
Yes.
So it switches its nature, actually. Yeah. And ensure as much as possible sound and solid contracts. So typical contractual provisions like applicable law, competent court, interest rates, costs, who bears them. These are all very good things to consider when you contract, or at least include in your terms and conditions. It makes our life easier, but also yours.
And speaking of this, of course, it's very important to make an express agreement on the applicable law and jurisdiction. So what this will prevent, for example, the debtor to lodge an opposition stating that you have chosen the wrong jurisdiction. But it's also important that you have these contracts in writing, or these terms and conditions handed over to the debtor.
With a link.
Yeah,
right
also
language.
Ellie, exactly in their language or in the language of the negotiations to be actually valid and applicable, because otherwise you really face the risk that the debtor can raise an opposition based on.
I remember when I joined the company that 11 years ago, I used to see on invoices mentioned these terms and conditions are inscribed with the Chamber of Commerce of the Netherlands under number 12345. And I was thinking, what effect does this have? It really means legally nothing because there's no factual handover of them. But a lot of people think or thought back then that this really works. So indeed, check for actually handover in the right language, retrievable, with the possibility to save.
And also, for example, according to the Italian law, the terms and conditions that have burdensome clauses needs to be signed 2 times, not only 1, 2. Not if it's negotiated, so if it's an agreement, go back and forth, it's fine. But if it's just send it over,
standard terms
needs to be signed 2 times to be applicable.
Yeah, higher conditions in it.
And of course, yes, this will help you to have a higher chance of recovering your debts and have a strategic advance, so you can choose where you want to go to court. And
it's actually how strong you are.
Exactly.
You define from the position how strong you are. But I saw in practice that our clients sometimes have difficulties imposing such terms against business practices. The most difficult position that I saw once for a client was that they were in the paper industry and it's a fully automated process. There's nobody actually taking in the order or issuing any documentation. It's computers linked to each other and the needs are sent from a software to another software. So there's no actual human to see terms and conditions or anything. It's an integrated system. And that's a difficult position to think of a legal way to have all of this in place. So depending on your industry, you can adapt. We definitely are able to assist with that as well, with all these nationalities that we have in our pocket in Amsterdam. So reach out and check with us what's possible. We would like to thank you for the time you've taken today to attend, and thank you, Enrica, as well.
Thanks.
Until next time.